Yeah, I just did yours. Now it's theirs.
Thank you, Your Honor.
Your Honor, the state intends to introduce evidence of Mr. Baldwin's role as a producer, even though Mr. Baldwin's role as a producer happened leading up to October 21st. As I just said a few minutes ago, Ms. Johnson told you nothing that happened before October 2021 in those civil cases is at issue here. The whole of the negligence, October 6 to October 21, that's the civil cases. That's not why we're here today. But the producer evidence is everything leading up to October 2021, October 6th through the 21st. They're trying to hold Mr. Baldwin responsible for what he did as an actor on the 21st because they claim he was reckless as a producer leading up to that time. That's a theory of vicarious liability in the criminal law that is not recognized. It's also far more prejudicial than it is probative because the jury's going to hear about what a producer does. They're going to hear about the producer being the boss, the buck stops with him, etc. And the risk is that they think Mr. Baldwin's responsible for what he did on the 21st because he's the boss, he's the CEO, he's in charge. But that's not a theory of liability, Your Honor. On top of that, there's no evidence at all, you won't hear any, that he hired Hannah Gutierrez-Reed, that he set the schedule, that he set the budget, period, full stop. What else did you hear? The state said Mr. Baldwin's role as a producer shows that he was keenly aware of the safety standards. Two issues with that, Your Honor. The state has said repeatedly in this case that Mr. Baldwin didn't violate the safety standards under Safety Bulletin Number 1. He violated New Mexico law. They said that, page 29 of their opposition to our motion to dismiss the grand jury indictment. The fact that Mr. Baldwin was a producer is entirely irrelevant, highly prejudicial. It should be excluded.
Your Honor, as the court is aware, relevance does not exist in a vacuum. So the evidence that the defendant was a producer is relevant to demonstrate to the jury that as a producer, he is aware of his safety obligations, the safety duties, and there will be evidence of the Bulletin Number 1, which sets out movie set safety rules and how Mr. Baldwin indeed violated those. I think what Ms. Morrissey indicated in her response is that he did violate New Mexico law. But to demonstrate that the defendant's conduct was reckless on set, the state is also going to introduce evidence that he violated these set safety rules that are in place for actors and producers to follow. The arguments of defense, they go to the weight and not to the admissibility. They can cross-examine the witnesses because many state witnesses are going to testify that the defendant was the boss on set. And Your Honor, with regard to what this is relevant to, it's relevant to his recklessness because we have to establish, again, it's not just in a vacuum, that the defendant's conduct on this set was reckless, and therefore, on October 21st, he should have been aware that his conduct of pointing a firearm at another human being, cocking that hammer, and pulling that trigger is reckless conduct. And so I think that both sides quoted the producer agreement. There are no limitations to this producer agreement. And it goes to the issue of the defendant's reckless state of mind. And Your Honor, I just wanted to briefly address something that I think was relevant to the...
Tell me what the safety bulletin says that the producer, you're referring to Bulletin Number 1. What are you relying on?
Well, there are a number of requirements as it relates to firearms, that the actor and producers are responsible for the safety of others on set, for the safety of themselves and of others on set, that they are to treat a firearm as though it's always loaded, do not point a firearm at another person.
I thought that was for the actor.
That is also, it's for both, Your Honor. These are set safety rules.
But what about, so you're not even relying on that?
We are, Your Honor.
In your response, you said that you weren't talking about the SAG guidelines. You were talking about New Mexico law.
Well, Your Honor, I think that these are two different issues that are being conflated. So Mr. Baldwin is charged with involuntary manslaughter under New Mexico law. And how do we prove that? We prove that by demonstrating his conduct, not just on October 21st, but in the days leading up, that by violating these on-set movie set rules, that his conduct was reckless. Because it's not recklessness in a vacuum from
You're talking about the gun, okay? So tell me what you think he did wrong as a producer.
So not just about the gun, Your Honor. So there are two, and that's what I wanted to address. There are two components here. So we have his conduct as it relates to the gun, but then his conduct as it relates to, for example, rushing the armorer to reload that gun. That goes to demonstrate his recklessness. There's no regard for the safety of other people. When you're rushing the armorer to reload this firearm, mistakes can happen. And so with regard to his producer role, there is evidence that will be presented that Mr. Baldwin, as a producer, should be aware of all of the safety regulations.
Okay, so I did have trouble wrapping my head around this, as you can tell, okay?
I understand.
So the jury's going to hear this and they're going to go, well, Mr. Baldwin was the actor that was rushing, but he was also being a producer at the same time.
It goes to, Your Honor, because it goes to the recklessness. So he is a producer, and his contract states he's also the leading actor. So he's got a dual role, and with both roles, he fails in maintaining the safety of other people. See, what the defense is trying to do is just basically pigeonhole Mr. Baldwin as just an actor who relies on everybody else, and he relied on this armorer to not give him a gun with a live bullet. But his role as a producer requires him, there are more duties imposed on him as a producer. And those duties include, and there's expert testimony that will be presented, that his duties as a producer,
Maybe. We haven't gotten to that yet.
well, I understand, Your Honor, but if the court allows the expert testimony, the state will present evidence that the defendant had not just his role as an actor, but as a producer, it's heightened in the sense that he is supposed to be aware of the regulations, of the safety, and that's the most important thing.
I'm just having trouble with this. Okay, I don't understand how you're going to say as a producer he shouldn't have, as an actor and a producer he shouldn't have he shouldn't have said quick, move.
Well, but so as an actor, of course, he shouldn't have done that, but also as a producer, Your Honor, he is the boss. And as the boss, he is responsible for the safety of other people. So it goes to his state of mind, his willfulness, that he essentially, as the boss, failed the people who worked around him. And it gives him the power to control the safety. So as the producer, he has the power to control safety on set. And there was a tremendous lack of safety on this set. And so as the boss, he's emboldened to do whatever he wants to do. So this goes to the willfulness that the state has to prove.
Producer to do whatever he wants to do.
Because you're going to hear testimony from witnesses, if the court allows this, who will say he was the boss, he was calling the shots, he would rush people because without regard.
Maybe that's his personality as an actor.
Well, but that's irrelevant, Your Honor. With regard to his role as a producer, he has responsibilities, and he has a responsibility to maintain the safety of the set. Whereas an actor, perhaps those may be lessened, but as a producer, those are heightened. And so it's relevant to demonstrate his willfulness, the willfulness of his conduct, that on October 21st, he once again disregarded the safety of Ms. Hutchins and Mr. Souza and pointed that gun directly at Ms. Hutchins. And so that is why this is relevant. We can't look at this in a vacuum. And in fact, the court in State versus Duncan noted that relevance does not exist in a vacuum. Instead, it's the logical relationship between evidence and a proposition and issue that the party seeks to prove. we have to prove willfulness, we have to prove recklessness. So in order to do that, the fact that he was a producer and the boss is absolutely relevant.
Let me ask you something. So in the involuntary manslaughter, with respect to the first negligent use of a deadly weapon, okay, that's not the producer, that's the actor.
That is the actor, but he's also charged in the alternative.
The alternative, that he failed to check the gun.
It's more than that.
Well, that is what was given to the grand jury, that he failed to check the gun and pointed a loaded gun at a person. That's what it was in the grand jury. So you want the producer you want to introduce that he was the producer and what he was required to do to be able to prove that alternative theory that he was supposed to check the gun.
Well, and that he wasn't supposed to point it at another human being and to pull the trigger. And so, and as a producer,
how does his role as producer, as a producer, he wasn't supposed to do that?
Well, his role as a producer goes to what he is required to know when it comes to safety of others. He has a responsibility to ensure the safety of other people. So it goes to the issue of his willfulness, that on October 21st, when he points that gun at Ms. Hutchins, he should know that as a producer, he's responsible for her safety, because that is one of the things that producers are responsible for, safety on set. And so the fact that there was a lack of safety on this set, Mr. Baldwin should have known that by his action of what he did, moments leading up to the shooting of Ms. Hutchins, essentially show a willful disregard for his safety and recklessness. So it's not a theory of prosecution, it is evidence that goes to prove an element of the offense. And we would respectfully ask that the court allow the introduction of the fact that he was a producer, and that as a producer he has obligations to ensure the safety of others.
And who's going to be your expert witness on that?
May I have a moment, Your Honor, to confirm? So we have two witnesses, Mr. Carpenter, who testified before the grand jury. In fact, he testified about the producer role. And then Kent Jorgensen, who is one of the individuals involved in drafting and updating the safety bulletins for on-set safety.
You know that Brian Carpenter was not an expert admitted as a producer in Hannah Gutierrez. He was a firearm expert. And he has not been admitted as an expert because there was no judge to get him to be an expert at the grand jury. So he has not, at this point, been admitted as an expert as a producer.
Right, and we would tender him. Obviously, the court will have to do its gatekeeping duty and role. Mr. Jorgensen, however, and in fact, I think there's a motion pending about Mr. Jorgensen, but Mr. Jorgensen is also an expert on this. He's familiar with what the safety guidelines require of producers and of actors. And so these are germane issues that the state is required to prove, and we'd ask that the court allow the state to introduce this evidence.
Thank
you. Your Honor, I hardly know where to begin, because I honestly don't understand the theory or the facts that they intend to articulate to demonstrate that on October 21st, Alec Baldwin, the actor, committed involuntary manslaughter. They said, well, the safety bulletins explain that. Two things. Number one, they already said in their response that the safety bulletins weren't violated, New Mexico law was. Number two, look at those safety bulletins carefully. I'm sure Your Honor's read them many times. They say nothing about the producer not pointing the gun. They say the exclusive responsibility of gun safety is on the prop master, the armorer, the first assistant director. Doesn't say anything about a producer. There are a number of actors doing the same exact thing that was required by the safety guidelines. Those are SAG guidelines for actors, armorers, the first assistant director, and the prop master. They say, well, maybe it's because Mr. Baldwin was rushing before October 21st, and there, as a producer, I'm not sure what that distinction is, producer, actor, and therefore on the 21st he was. But you just excluded the evidence of him rushing because that's propensity evidence. That's inappropriate. The fact that we're so confused about what the theory actually is goes directly to the prejudice that will far outweigh the probative nature of this testimony. And we'll get into Mr. Jorgensen and Mr. Carpenter later, unless Your Honor wants to hear about why they are not qualified to testify as experts on producers. I'm sure we can push that on. But the reality is this will confuse the jury. This will be highly prejudicial. They want to show that he's the boss, and therefore on October 21st, as an actor, he committed involuntary manslaughter. That is highly prejudicial, inappropriate evidence, should be excluded.
All right, so what I think is more appropriate is I'm going to revisit this, make my ruling, no more argument on it, but I think that we should do well, you didn't raise, Mr. Carpenter, except duplicative testimony. And
no, that's just the cumulative expert motion, Your Honor. That's correct. We raised Jorgensen.
Right.
If you want to do Jorgensen now, I'm happy to come back up and talk about Jorgensen.
All right, let's do Jorgensen.
Okay. Now, the state intends to offer Mr. Jorgensen on two issues. One is the role of a producer in managing the safety of the set, and the second is the safety bulletins that govern actors on movie sets. Mr. Jorgensen should be excluded. First things first, on the evidence of producer, his opinions on producer. Mr. Jorgensen has never been a producer in his life. He was a camera grip back 25, 30 years ago, never been a producer. We asked him, what is the basis for your testimony as to what producers do, know, what their obligations are on a movie set? He said, well, it's because I get to sit at the kids' table, these are his words, and listen to the adults talking. Your Honor, this is not the kids' table. This is the adults' table. Mr. Jorgensen has absolutely no expertise, and sitting at the kids' table doesn't allow him to sit over there and give testimony about what it is a producer is required to do on a movie set in a criminal trial on involuntary manslaughter, number one. With respect to the safety standards, Mr. Jorgensen didn't draft the safety standards. He's not a gun expert. He was a camera grip. Sets up camera angles and scaffolding, etc. He is not a gun expert. He's not an armor. He's never been a prop master. He's never been a first assistant director with the safety obligations. His role, as he described it, is administrative. They want to draft safety guidelines. Mr. Jorgensen says, I'm going to go find gun experts. I'm going to delegate the drafting of safety bulletins to gun experts. They're going to draft it. Not Jorgensen, the gun experts are. And then the gun experts are going to send it back, and Jorgensen wordsmiths and edits. But it's the gun experts who determine gun safety standards on movie sets, not Mr. Jorgensen. He has no basis to offer an expert opinion about gun safety standards, what the standards mean, how they're supposed to apply, because he didn't draft them. He's not the expert. He doesn't know anything about them other than how they got drafted. But how they got drafted is not an issue in this case. His evidence, his opinions should be excluded.
Your Honor, Mr. Jorgensen teaches producers about their responsibilities with regard to set safety. He's going to take the witness stand. He can outline his experience, the position that he holds that allows him, that puts him in the position where he teaches producers about set safety. So I want to be clear. I am not calling Mr. Jorgensen so that he can come and just generally talk about this is what a producer does. I am calling Mr. Jorgensen to come in and talk about the producer's responsibility with regard to set safety. And Mr. Jorgensen is acutely familiar with this because he actually teaches producers what their responsibilities are and how they can have a safe set and avoid getting sued for killing someone. So we've got that as the first issue. Mr. Jorgensen is indeed one of the people who drafts the safety bulletins. I'm not sure where the confusion came in. Mr. Jorgensen is the chairman of the It's on the tip of my tongue. The industry-wide labor relations, it's on my computer. My apologies. So in that role, what Mr. Jorgensen does is, here's how it works. Representatives from all of the different film unions come together. So we've got somebody from the Directors Guild, and somebody from the Producers Guild, and somebody from IATSE, and that's who Mr. Jorgensen is. They all get together and they agree and draft these safety bulletins. Mr. Jorgensen is one of those people who sits at the table who drafts these safety bulletins. So his testimony is entirely relevant, one, because he actually drafts the rules that Mr. Baldwin is required to follow, whether we're talking about him as a producer or an actor or anything. And number two, Mr. Jorgensen sits with people from the Producers Guild of America to sit and discuss these safety bulletins and whose responsibility is what, in addition to teaching producers how to do this. So I think that his testimony is absolutely relevant with regard to, these are the safety bulletins. He lays a foundation for the safety bulletins. These are how the safety bulletins are created. This is a safety bulletin. This safety bulletin says, don't point a gun at anyone. Keep your finger off the trigger. Assume that anything that you point the gun at will be destroyed. Those are the safety bulletins that Mr. Jorgensen participates in developing. So his testimony is wholly relevant. Now, whether or not the court decides that Mr. Jorgensen's testimony with regard to a producer's responsibility as it goes to set safety is something that I think the court has indicated that you may want to reserve ruling on until you see and experience how the trial is unfolding. But there's no question that Mr. Jorgensen gets to come in and testify about the safety bulletins that he himself participates in drafting. Thank you.
Just a few points, Your Honor. The fact that Mr. Jorgensen is allowed to teach at some university about how people shouldn't get sued in civil cases, it doesn't make him an expert in this court. He's never been a producer. He's not an expert in being a producer. The kids' table doesn't allow him to sit at the adults' table, period, full stop. He also is not a gun expert. Didn't draft it. They're going to have Mr. Carpenter come and testify about safety standards with respect to using the weapon, pointing it, not pointing it. Now they want a cumulative expert, Mr. Jorgensen, who doesn't actually develop the guidelines. He's not the gun expert. He admitted that. He doesn't develop the standards. He said, I hire gun experts to draft those standards. They're going to have two experts, one of whom clearly not qualified on gun safety, Mr. Jorgensen, testify, and then put Carpenter in too. This is an afternoon, a day of testimony of cross. We already have a short schedule, Your Honor. You should limit this testimony. He's not qualified to give opinions on these issues.
Thank you. The court makes the following ruling. The court will accept Mr. Kent Jorgensen to be able to testify before the jury as to what the guidelines say, but he has no qualifications to opine on what a producer does. He doesn't know how a producer implements those guidelines. So he can say these are the guidelines, but he needs to be a producer to say, this, as a producer, this is how I meet these requirements. The other thing noteworthy about Mr. Jorgensen is that based upon his pretrial interview, which is what would have been the time to let the state know, or I mean the defendant know what he was going to testify about, he was all over the place. And basically, he was like, well, I relied on Ross. I didn't talk to anybody. So yes, he will have hypotheticals about, and he may maybe sit over there in the gallery while he's and listen so that he can opine. But I think that interview indicated on top of it that my finding that he's not qualified to know what a producer does. So he can testify about the SAG guidelines, but he cannot opine on whether what Mr. Baldwin did as a producer was good or bad. All right, I'm going to revisit the producer. I'm going to make the following finding. I'm having real difficulty with the state's position that they want to show that as a producer he didn't follow guidelines, and therefore as an actor Mr. Baldwin did all these things wrong, resulting in the death of Halyna Hutchins, because as a producer he allowed this all to happen. I think that when you look at the relevancy, I think that one of the reasons why I think I'm having a hard time wrapping my hand around it, to be able to say Mr. Baldwin, because he was a producer and he was the boss, although there are more than one producer, and he couldn't do anything without, looking at those contracts, he couldn't do a thing without running it by, including hiring somebody, without running it by whatever that entity is in the contract. But I do not believe that it has any tendency to make more probable than it would be without the fact that Mr. Baldwin individually as an actor committed involuntary manslaughter through negligent use of a deadly weapon and the alternative theory. The probative value is not substantially outweighed by unfair prejudice and certainly confusion of issues to the jury. So I'm denying evidence of his status as a producer.